Hi everybody, my name's Brent Ripley. I'm an estate planning attorney in Utah, and I would like to explain to you the most important difference between a will and a trust. And the best way to do that is to consider the basic estate planning problem, which is how do we transfer property from people who have died to people who are living, since those people who have died are not able to sign deeds or other transfer documents. Now, as we discuss this, remember that this is a general educational video and I'm not giving anybody any specific advice. Always get assistance from a qualified professional before making plans or drafting documents that your family may have to live with for a very long time. This is worth doing right. So imagine the following transaction when you're thinking about how a will works versus how a trust works. Let's say you're going to buy this home, and the owner of the home are John and Jane Doe. Now, as you're going to close this transaction, you learn that John and Jane Doe have actually died, and that somebody named Jim Doe is going to show up at closing to sign the deed and take your money. Now, you don't know who Jim Doe is. He's not on the deed. He says he's the son of John and Jane, but you don't really have any way of knowing that. So the question is, are you going to give Jim Doe your money? Well, of course not. Even if you did, and even if he signed the deed, there wouldn't actually be a transfer of ownership. Jim has no authority to transfer property that's not in his name. And just because John and Jane have died doesn't give him that authority. What if he has a sister who claims the same authority? So how do we transfer that property? If John and Jane are dead and can't sign the deed, and Jim can't sign the deed because he's not on the deed, what do we do? Well, the only way to go about this at this point is to get a court order that authorizes Jim to sign the deed. And that happens at probate court. At probate court, a will is filed, or if you die without a will, then a petition is filed saying you died without a will. The court will appoint a personal representative and give that personal representative authority to transact business on behalf of the people who have passed away. If you own property in your own name at the time of your death, then probate court is the only way to transfer that property to somebody else. There's no other way to do it. Now, there are ways to avoid probate, and a lot of people would like to avoid probate because it can take a lot of time and it might cost a lot of money, and you just never know how things are going to shake out. But you have to plan ahead to do that. And I've got another video that talks about different ways of people avoiding the probate courts. But let's assume that these people used one of the more common ways, which is a living trust. So let's go back to that transaction, and let's say that you're going to buy this home and the owner of record is the John and Jane Doe Living Trust. It's not John and Jane Doe themselves, it's their living trust. As you go to close, you learn that John and Jane Doe have died, but that doesn't matter to you because the trust itself has not died. The trust is still alive. And the trust names a new trustee, in this case, Jim Doe, and Jim has all the authority under the trust to sign the deed and transfer the property. In this case, everybody's happy. You're happy because you get the property. Jim's happy because he can sell the property. John and Jane's heirs are happy because the property gets sold. The title company can insure the transaction, and the county recorder is happy to record it, and you are the new owners of that property on the deed. And this all happened with no judge, no court filing, no waiting, no publicity, with clear instructions for heirs. Remember also that a trust helps your family manage property while you're alive in case John and Jane maybe are still alive, but they're in a nursing home and they can't make decisions for themselves. We can still take care of that property on their behalf through the trust. So I'm happy to answer any questions you might have about your situation. I'm happy to talk to you either in the office or on the phone. I meet clients in Provo, Salt Lake City, and St. George. My phone number is 801-377-9787. I'm happy to review any existing documents you might have and give an in-depth review of your current needs, and I'll answer all your questions, and all of this at no charge. I don't ever bill by the hour. I've been doing this for nearly 20 years, and I don't practice any other kind of law. So there's no fee until you and I both decide on the work that needs to be done and the appropriate price for doing it. I'd love to talk to you, so give me a call. and like or share this video with other people who you know have the same questions. Thank you, and I hope I've made things a little clearer for you.